He'd probably be doing a jig right now.
There is no one exclusive Métis in Canada, any more than there is no one exclusive Indian people in Canada. The Métis of Eastern Canada and Northern Canada are as distinct from Red River Métis as any two peoples can be. As early as 1650, a distinct Métis community developed in Le Havre, Nova Scotia, separate from Acadians and Micmac Indians. All Métis are Aboriginal people. All have Indian ancestry.
It can't be just for some Aboriginal people and not for others.
It created a massive sense of validation, specifically. You know, we always knew who we were, but here we are in the highest court in the land, and a colonial court at that, recognizing us as who we are and validating the rights that we have. You know, you can know who you are, but if it's not recognized externally, it can be very heavy on a person. And so having that court recognize that, it was, you know, initially it was a celebration amongst all of us. And, you know, still today it provides an avenue for hope that we will be able to come to terms with the federal government and the Crown, and that we will be recognized, and that we will be able to fill our space in Canadian society and as well as our Indigenous communities.
What we are talking about is the equality of people here.
I think the federal government not being able to turn their back on non-status and Métis people, Indigenous people who were enfranchised for various reasons, whether it's the math that they're using today for the second generation cutoff, or in the past, whether, you know, you wanted to be employed or live off the reserve or participate in the military. All the various reasons, you know, women marrying non-Indigenous men. So it has brought back responsibility for the federal government to recognize these people that it attempted to remove from its responsibility as Indigenous peoples, and recognize them as Indigenous peoples that they need to find platforms to negotiate with and to provide for and to recognize the rights of.
So you got to be careful how you identify yourself. Either you're an Indian or you're not an Indian. You're a Métis or you're not a Métis. You're an Inuit or you're not an Inuit.
I became responsible for Daniels in 1999, and I stayed responsible for Daniels as lead counsel until the final decision in the Supreme Court of Canada in 2016. The problem that we were addressing was the fact that non-status Indigenous people did not receive the same benefits that were given to status Indigenous peoples, despite the fact that they shared their circumstances and conditions, despite the fact that all governments recognized that they had the same needs. And in fact, the needs of the non-status people were even greater because they didn't receive federal programming. There was a logjam where the feds weren't going to provide those services. The provinces weren't going to provide those services. The feds and the provinces were fighting with each other. Both recognized the need, but neither was willing to blink. It was a question, how are we going to break that logjam?
I wish my father was here. Honestly, I think as happy as he would be, I know that my father, in his mind, that he would already be thinking about the future and what's the next step and what do we got to do now.
There's me, my mother, my grandmother, my grandfather. My grandmother and my grandfather are both full Ojibwe, my mother full Ojibwe. And then, so why does it stop?
We have organizations that are set up to represent the First Nations and the Métis and the Inuit, but they're not necessarily comprehensive. There's still many of the Indigenous peoples who aren't able to have their rights or needs recognized through those organizations. A lot of those organizations, it's land-based, it's being associated with living in a specific territory or region or community. And if they leave those territories or those regions or those communities, then they no longer have access to those supports. And CAP being around for 52 years, originally it was started to get the rights for women who faced gender-based discrimination and lost their status. And as matriarchs do, they opened that door for all of the Indigenous people who were losing their rights and their capacity to receive supports and services based off various forms of discrimination, and the main one being where they live. So CAP has always been there for those people, and we're still there for those people today. But now with the Daniels decision, we have a direct line to advocate for them, and that's with the federal government and with the Crown.
We're doing the same thing. We're working towards our missing and murdered women. We're working towards wage equality and different things like that. Like, we should be working together, not being separated.
So for CAP and our affiliates, what we need to be doing is pushing those decision makers within the federal government for recognition for the rights for the urban Indigenous population, the off-reserve and the non-status. We need to continue to advocate for housing, for healthcare, for education. We need to be pushing for us to be included in important discussions like missing and murdered Indigenous women, girls, Two-Spirit, men and boys, which, because of the distinction-based approach, we've been pushed out of recently. They're not recognizing the non-status peoples. They're not recognizing the communities that the non-status people are choosing to represent them. They're not representing the communities that many urban and off-reserve Indigenous peoples choose to represent them. They're not recognizing the communities that many Métis choose to represent them. They're not in the same with Inuit. We're seeing many more Inuit members in our organizations as they move to urban areas. It's just not the role of a healthcare provider to act as identifiers of Indigenous peoples. That relies with the communities that they're a part of. And to be denied healthcare as a member of an organization that many Indigenous peoples choose to represent them, to advocate for them with, and who they gather with for community and cultural support is pure discrimination.
If I'm an Indigenous woman living in Quebec City and my kid has an earache, I don't have the luxury of getting on a plane and flying 14 hours away, where my First Nation is, who can, service my kid's ear, in maybe 2 weeks' time. So I understand that these are, pressing needs, and most non-status Indigenous people live in the city, and they need, culturally sensitive services like everybody else gets. Canada's still discussing with the provinces, still having problems, who's going to pay. The needle is moved. Yeah. Canada's provided more. Canada's given a little bit of recognition to
distinction-based groups, though.
No, also to, CAP.
For thousands of years, we have cared for one another through knowledge rooted in land, in ceremony, in language, and in relationships. Many of the medicines now found in pharmacies have their origins in knowledge that our ancestors developed and passed down through the generations.
Well, one of the things we were told by the Crown was that CAP is one of the leading data providers when we were able to participate. That CAP provided more data than some provinces did. CAP is constantly bringing its communities together at the provincial territorial level, but also nationally, to gather that data and consult with our people. We're very proud of the work that we do. And because CAP never gets handed anything, our work needs to be good work. Otherwise, we won't see any funding in the future. And so we're very proud of the data that we provide and the voices that we're able to represent, the lived experiences that we're able to bring to national conversations when we're given a space at the table to do so. Harvesting rights have been a big challenge for Indigenous peoples. We've gone from the point where the arguments have been that we should be doing it like we did 300 years ago, to them being recognized today, that we have the capacity to harvest and that we have the capacity to make an income off of those harvesting. And so for non-status people and the Daniels decision, people living off reserve and in urban areas, that those rights need to be able to transition to them in those spaces. And we see Indigenous peoples pushing for those, and as always, we need to go through the legal system to have those things recognized. But we're seeing more and more the courts awarding Indigenous peoples with those rights, and that we do have the rights to harvest, and that we do have a right to use that harvesting not just for food, social and ceremonial reasons, but also for our own economic benefit, whether they be on reserved territories or traditional territories or in and around urban areas.
We have UNDRIP legislation in Canada now, which is a whole different legislation than the Indian Act, and it's an international sort of law, right, or commitment. So Canada is being brought into the spotlight. And of course, our leaders are making presentations to the United Nations in New York and Geneva all the time, right? And so I think, that the day of sort of reckoning for our national government and other governments in Canada is here. But it's a good thing. Like we should be so proud of ourselves because of what, if you know the true history, the truth of our treatment by Canada as a government, as a nation, we just can't help but move to a better place.
Some of those pronouncements would be very difficult for Canada, which likes to think of itself as an international human rights promoter and does do very good work in the international arena, and I believe would have been, a non-risky way of exploring how to bring pressure on Canada to, let's state what CAP wants, to bring programming to a larger class of Métis and non-status Indians up to speed with what's being provided to status Indians, because it's not now. And there are still many people, Métis non-status Indians, who don't have responsive health care, adequate responsive educational facilities, adequate responsible social services that, are attuned to Indigenous peoples that would help these peoples progress. And, that's a large body of people who could be developed further, to realize their potential and have happier lives and, more successful lives, and that would ultimately be contributors to Canada.
Yeah, and it's kind of intimidating too at this point to go back and try to get my son's status, because I don't know, I just have this fear. Like I had a fear when my daughter went. They know they're Native. So why does their cousin have status and they don't? Why does their friend have status and they don't? And some of the lineage is very similar.
Off-reserve people, whether they're status, non-status, Inuit, they've been pushed aside. Just because we choose not to go to our home reserves, if we're welcome there, doesn't mean we're not rights bearers.
There is currently litigation that's been brought by CAP to challenge the exclusion of non-status Indians from post-secondary education benefits. And since Smokey Bruyère's time, it's become even more pronounced because you now have separate programs each for Métis through the affiliates or former affiliates of the Métis National Council, for Indians, as long as they're status Indians, First Nations people, but you have to have status, and for registered Inuit. But non-status are completely excluded. So that's being challenged on equality rights grounds under Section 15 of the Charter. And we're starting to get documents, from the government, which they say defends their decisions.
The government should take a more proactive approach, and so the next lawsuit would be coming, which would be getting rid of the second generation cutoff.
It's an interesting one, right? Because all non-status people have been recognized as Indigenous anyhow, and that the federal government is responsible for negotiating with them. So the second generation cutoff is one of the methods that people become non-status today. In the past, it was through various forms of discrimination, like joining the military or a woman marrying a non-Indigenous man. But today, that's how non-status come to be, is through 2 generations of having at least one parent who isn't entitled to status. And so the Daniels decision and the second generation cutoff are directly linked. They're almost one and the same thing. I think we need to keep working like we have. We need that grassroots community to really stay strong and to really keep working together and understand that even though we have that legal recognition, there's still a lot of work to be done in policy. We have to build bridges with the other national Indigenous organizations. We have to be able to move past a broad approach on the distinction-based approach that the government's currently taking. But we need to support the various distinctions in their interests as well. We need to really push for the interests and recognition of non-status, urban Indigenous status peoples. We need to make sure that we come together as a community. It has to be a healing. We have to really create that holistic environment where nobody's left behind, where the communities are there for the best interest of the individual and come together with all of the other Indigenous peoples as well as all Canadians.
As long as there are unresolved questions, unresolved wants and needs, we have to have an organization that is going to, that is well equipped, first of all, and to articulate those wants and needs. And if we don't have that, then we're just going to, disappear as a race of people.